back to our special Heritage Day edition of The Morning Show. Heritage Day celebrates our diverse cultural traditions, but how do our laws safeguard our heritage? In this segment, we're going to examine the complex relationship between cultural rights, freedom of expression, and the law. And joining us this morning to shed light on the legal framework that protects our rich cultural heritage in South Africa is attorney, notary public, and managing director of Simelane Attorneys, Phumelelo Simelane. Good morning. Welcome to The Morning Show.
How are you?
So good, thank you. I'm very excited to jump into this conversation. Are you well? Are you feeling the Heritage Day vibe?
I'm feeling the Heritage Day vibe, and thank you for having me.
Of course, of course. So this encompasses so many elements of our heritage, whether it's our traditions and customs, language rights as well, land rights. So to start off the conversation, can you give us a brief overview of South Africa's cultural heritage landscape from a legal perspective, and what role the law actually plays in promoting cultural diversity and inclusivity?
So, of course, we have a very diverse cultural heritage as the nation. I think this is predominantly seen by the various cultures we have in the country, the languages that we have. But the starting point, of course, in promoting language is obviously the Constitution of the Republic of South Africa, which grants the right to freedom of expression, which is one of the greatest rights we have in the Constitution, that do promote the right to heritage. And also the Constitution also has an obligation that that says when interpreting any law that deals with customary law primarily, it must always be in line with the Constitution. So I would say the bedrock, the cornerstone of protecting our heritage and promoting heritage is the Constitution. So that's the framework that governs all laws. There are pieces of legislation that governs particular laws, but from a broad overview of our heritage, I would say we start off from the Constitution.
Perfect. So I want to jump on to what you just mentioned now about our customary laws, our traditions and our customs, right? There's certain cultural practices that have come to the fore. I'm thinking of the rule of male primogeniture, right? Where only the male heir could inherit, or things like the tradition of utwala, which we know is still practiced in certain rural communities. How does the law balance, the respect for our traditions and our customs and our cultures with national heritage interests and the Constitution?
Again, we still have practices like utwala and sorry, what was the other one you mentioned?
The male primogeniture.
Male primogeniture, which was essentially a law that only the eldest male could inherit, and all daughters could not inherit, which was outlawed by the constitutional case in the Bay case. So any law that is inconsistent with the Constitution is certainly void and outlawed. So as much as we want to develop our customs and want to work on our customs, they must be consistent with the Constitution. Once it starts to be in direct violation of the Constitution, that's when the problem comes in.
We also see issues of actually preserving our traditional knowledge. What are the legal mechanisms for protecting traditional knowledge against exploitation?
So in 2019, our president signed in a law, I just can't remember the exact name, but it was for the promotion, protection and management of the indigenous knowledge, which aimed to make our indigenous knowledge a national asset. And this was primarily done to preserve and protect our national heritage, and to also ensure that communities in these spaces were not exploited. So that's one of the pieces of legislation that were primarily enacted to protect our national assets and make it national assets and to protect our laws in that sense, our customs in that sense,
Of course, I think that's actually very helpful, so that there's preservation of our traditions and our customs and the knowledge for future generations, right?
Exactly.
So recently we've seen so many challenges regarding, our cultural practices conflicting with workplace and school policies. Just recently we saw with Pretoria Girls High, the issues of their policies with regards to hair. There've been legal legal, cases, people have actually gone to court for being able to wear their hair in afro or wear dreadlocks at school, in the workplace, and at universities as well. And this also extends to things like your traditional attire versus your dress code at work, or even religious observances versus, the workplace policies and your leave. So what laws are in place to actually protect the cultural rights of workers, of school pupils, of students, and how can both employers and educational institutions make sure that they protect and respect these rights?
So sorry, that's a very loaded question, but just to break it down a bit, again, bedrock, the cornerstone is the Constitution, but we'd have to balance this with individual policies. Again, you have the right to freedom of expression, which allows you to wear your hair out, allows you to have dreadlocks, allows you to, dress in how we are dressed today, which is nothing wrong. And it's such a sad point that we only do it once a year. But there's nothing stopping us, because we have these various rights and cornerstone rights, Bill of Rights, of right to expression. But we need to find a balance to it. So it's like a constitutional balance of these rights, and also a policy rights from an individual perspective, from an employee sense. There's a dress code, specific dress code that the employer would want from a school point of view, to just try and also preserve integrity, and also have maybe one solid projection out there. So I would say, yes, of course, you do have the freedom of expression, but it's not absolute. You can't just do it because you have the rights. Now you can just practice it as you please. It needs to be practiced responsibly. Responsible as well.
So we were actually talking about this earlier. I'm just so puzzled that, the hair policies at school are still a thing. When I was at school, we still were having meetings about it and talking about whether we can wear our afros. So that is still such a contentious issue in many schools is very disheartening. But it's encouraging to know that we do have a legal framework in place that we can attend to.
It's a very nuanced area in our law, which is ever developing. And I think, again, it goes back to the cultural aspect of, we need to try and balance it out, and try to sort of express, but also express in a way that is very responsible. I would say it's a nuance in law. It's ever developing. Again, I go back to the Constitution, that we need to develop it in line with the Constitution. I think so. It must be a law, a right that is balanced fairly and not necessarily used in a responsible manner.
Well, I'm sure even today, wearing your Heritage Day outfit is a welcome respite from the usual suit and tie.
The usual suit and tie, it definitely is. But again, there's nothing that stops me from dressing the way I'm dressed.
Of course,
we've seen a lot of our colleagues in the legal fraternity who wear their hair out, which is also a sign of the progression of the law, that, we're trying to move away from the traditional westernized way of doing things. We're trying to get back to doing things heritage way, in the customary, in the African way, so to speak. And it's just not just the African way in the sense of just Africans, but South Africans and how they practice their various cultures.
Perfect. So after the break, I want us to turn our attention to language rights. So stay with us, TMS family, as we continue our conversation with Phumelelo Simelane this morning on The Morning Show.